let's resume. Shall we invite the witness to come back again? Raymond Wong, please wait a minute. There's a point of order to deal with. All right, have you managed to read 5.8? Okay, let's resume with the second part of our hearing today. Mr. Raymond Wong. Chairman, I was asking Mr. Tong about the 4 occasions. That is the 4 occasions on which, before the CE's approval was given, air passage was already booked. So I'd like to ask who gave the approval for the procurement of air passage. So can he give us the relevant document? All right, just now we were referring to a particular document, IRC report, and also the document supplied by the ICAC on his itinerary. So in the itinerary, when was that prepared? So Mr. Tong said that it was compiled afterwards. So can we confirm when the itinerary was prepared? Was it before January the 5th, or after January the 6th, or after the 19th of January? So there are several dates here. So can he verify? And also, Mr. Raymond Wong was asking about the procurement of air tickets. When was that done? And who did the purchase? And who had the power to make the procurement? And who had the authority to do so? So he would also have to give us the dates. Gary? Yes, thank you, Chairman. I'd like to ask about entertainment and entertainment expenses. Can I refer the witness to IRC Annex 3? Which paragraph? And ICAC Form 569. This is a very simple form in Annex 3 to the IRC report. The reason why I refer to this document, this is a very important document, because in this form, well, prior to Mr. Tong's assumption of office, well, the former ICAC commissioner drafted this form, so that for whatever entertainment expenses and whoever the guest would be, the commissioner would be required to fill in this form as to how the funds would be spent, who would be the guest, and also the detailed food items, and also even beverage expenses would have to be included here. So every time where there's such entertainment activity, the form would have to be filled, and then they will have to seek the highest level of approval. That is, the commissioner's personal approval will have to be given before they can organize such activity. And in Mr. Tong's response to Raymond Wong's question, he said he was aware of this form. So what I'd like to take up is, all right, since you are aware of this form, did you know that, is it like what the IRC report said? That is, the director for the CRD, after it was in use for 6 months, and then it was no longer used for making application for approval for such entertainment expenditure, and were you aware of that? And did you know why it was suspended, and who gave the approval for not using this form 569? Mr. Tong. So that's in IRC report 3.8, 3.9, and 3.10. So can you answer that? So you can refer to those paragraphs if you want. Chairman, I did not notice that this form was being used and that it was suspended. I did not pay specific attention to the adoption of this form or the suspension of its use. Mr. Chen, all right, one of the authorities making or giving the approval for this form was the commissioner. That's my understanding. So my question for Mr. Tong is, during your term of office, all right, during the time when this form was used for more than 6 months, did you sign any document that is in this form? Mr. Tong? Yes, I believe so. Well, Chairman, since the witness is aware of this form, you also sign on this document or form. How come you allow some entertainment activities held by the ICAC without the use of this form? Or did you request that for every entertainment activity organized by the ICAC, this form should be used? Mr. Tong, well, according to my understanding, the way that application was made for the holding of entertainment activity other than using this form, well, as far as I understood it, I understood that some of the applications would be made in the form of a file minute or file. So my understanding is that whether or not it's made via such forms or other files, it would be okay. That's why I did not look into it in depth. All right, my understanding is that I suppose that would be made or done in memo form and so on. So what's the purpose of coming up with this form in the first place? And the purpose of this is to ensure that all entertainment expenses would be regulated, including food, beverage, and other expenses. How come you have to resort to other formats? And I'd also like to follow up on this. Chairman, I think something to do with entertainment. All right, the decision not to use this might have to do with certain entertainment activities. All right, according to the ICAC, R60/30 is about beverage. It's a form for the consumption of beverage. My understanding is that in 2007, Mr. Tong assumed office as the commissioner for ICAC. And this form was introduced in 2008, and after 6 months in use, it was suspended. But then if you refer to this form for the consumption of beverage, in 2008 and 2009, all of a sudden, the stock of hard liquor shot up. In particular, hard liquor like Multi, when compared to 2007 and 2008, it shot up very drastically. But then with the suspension of the use of this form, all of a sudden the stock of Multi increased from 9 to 14, and then the next year from to 15, and then for the next year 26 bottles. So there is a reason for me to suspect that with the suspension of this form, it would facilitate their procurement of hard liquor like Multi, because if you look at this table, if you want to procure Multi, you will have to enter an entry into this, but then that would definitely represent an overrun of cost, and therefore you try to do away with this form in order to facilitate your procurement of hard liquor like Multi. Is that the case? Well, Mr. Tong, this is your opinion, is your view, and I cannot just rely on this figure in confirming or otherwise. What does that mean? What's your view? Whether or not I subscribe to your view or not, I don't think it's I don't think it's good for me to just base that on this form. But then, do you agree with what he said? And if you do not agree, and if you think that is not right, then you will have to tell us a reason. Well, I think we cannot just rely on a figure and a change of it in coming to this conclusion. If the honorable member was referring to the increase in number during a particular period of time, well, between 2009 and 2008, if you look at the number of Multi being procured, I think the figure was about the same. And then in 2009, yes, the figure was somewhat higher than that in 2008. But then if you look at the note to 2009, well, 6 bottles of Multi were bought on behalf of the administration branch for a particular activity, and that did not show that it was a steady growth, or it as to in 2011 why 26 bottles of Multi were bought. Well, I don't know the reason. There might have been special reasons for that, but that Mr. Chen was asking you. Well, with the suspension of the use of that form 569, as a result of the suspension of that form, in procuring Multi, you do not have to declare, you do not have to register it. So in these circumstances, all right, if you had to register it, then it would have been very easy to spot that, because in your standing order, well, it says that since 2008 you would have to use it, but then you suspended the use of it, and in procuring Multi. So do you understand what he was asking you? And you said that you did not agree. Then you will have to explain why you did not agree. So can you tell us why you do not agree? Well, I do not subscribe to that view, because by simply relying on this figure, well, between 2007 and 2010, well, during the 3-year period, 94 bottles of Multi were bought. I do not see a growing trend. But then he already told you just now. He already read that out to you. Does he have to read it out to you again? All right. Without the use of that form, it would facilitate your procurement of Multi. So was that the reason behind your suspension of the use of a form? If not, then can you explain why? Well, you are entitled to say no, you do not agree, but then can you explain why you think that interpretation is wrong? You will have to explain to us, because we're just pointing out the fact to you. Well, on one hand, well, can I help you further? All right, can you refer to the IRC report? 3.8, I specifically pointed that out to you. I reminded you of that. 3.8, 3.9, and 3.10. 3.8, you said, well, it said that that form was introduced since mid-2008, and then in the next paragraph, 3.9, there was further explanation, and then in 3.10, Mr. Tong, in 3.10, in July 2009, ICAC CSO Commission Standing Order, am I right? So CSO means Commission Standing Orders. It was revised or amended. So when we read the document, that's the way to do it. All right, the reason why CSO has to be amended, well, you have a document available and then you're trying to use other documents, but then given the fact that CSO has been amended, and in 2008, 2009, there was an increase in the number. There was an increase in the number of bottles of Multi purchase, and CSO was also amended. You said and you told Mr. Wong that you read all the document, and we read the report very carefully. We read it word by word. So you have to be clear about the IRC report. All right, this is the IRC report. What we are trying to do is to get to the bottom of it from the perspective of value for money. All right, you have a form to fill out, and the purpose of that is to make sure that things are done properly. But then in procuring hard liquor, you do not use that form, and then the form was introduced since 2008, but then in July 2009, the CSO was amended, but then you're trying to do away with it. So can you explain? Chairman, I think you've answered the question already. So can you answer the question? I think the honourable member made an assumption, and the nature of that is an assumption. The use of the form and the process of using it. There is a specific procedure, and the officer in charge, through the recommending officer, will submit it to the commissioner, who will sign on the document. For the use of it, or otherwise, was there any attempt to avoid disclosing the fact that Multi was procured? Well, I cannot second guess what was on his mind, as I am not in a position to do that second guessing. There is no way that I can confirm or otherwise the inference made by the honourable member. Well, can I ask it in another way? Yes, please, Mr. Chen. All right, the ICAC or the then ICAC had two systems. One would require the filling of forms, and the other would require the application made by memo. In other words, there was no need to fill in a form, and the filling in of a form would ensure that all the entertainment expenses or expenditure would be regulated, and that would be done through you, Mr. Tong, as the commissioner, who would be required to sign on the form. And of course, the public would have expected that everybody in power would be exercising or discharging their duties in accordance to established rules and procedures. All right, in the ICAC, certain people would be subject to certain requirements and other people do not have to be subject to such requirements, then that would result in double standards. Yes, some forms might require that you will have to follow strictly Form 569, but then in other departments, well, in order to avoid certain circumstances from arising, they would try to deliberately avoid using it. So in terms of your regulation of the department or your governance of the department, that would be very confusing. And as head of the commission, how could you have allowed such double standards to exist? Mr. Tong. Well, can I talk to my counsel? Yes, please. Mr. Tong.
It's very simple. There is a criminal investigation. So you have to answer questions, but you have to decide whether your answer will have other implications. And you would decide how you will answer, but you should give us facts. The Director for Prosecution gave us a letter. We understood that there were different investigations. But here, we exercised a PNP under Cap 382. You have to answer our questions. In 2007, not 2007, I was appointed from outside the commission to be commissioner. I realized there were different practices in relation to application for entertainment expenditure by different departments. And I also was aware that within the commission there were different practices in different departments. I saw from the IRC report that after I was appointed commissioner in 2007, applications were different. When the CRD was using Form 569, it says that whether the form was used or not, the CRD did not include the cost of alcoholic drinks procured separately in the expenditure for entertainment. So all along, the CRD was of the view that beverages cost should not be included in the form. About the purpose of Form 569, I did not realize when the form was introduced what its purpose was. Yesterday, I asked the ICAC to supply me with the background information before and after the introduction of Form 569. I don't have the information with me, but it is readily available. Before Form 569 was introduced, there were some correspondence, some consultation within the Commission. So there were about 2 ranks under the heads, more than 2 departments. There was nothing in the documents showing that it was circulated to me, so I did not know about the purpose and the use of the form. Well, you said that the CRD did not know. Please refer to the IRC report, paragraph 3.7b. The ADM asked the CRD to include cost of beverages. Well, I am only reading it from the paper, so don't take it out of context. 3.8, 3.9 and 3.10 follow on from 3.7. Boy. Mr. Chen, that's why I asked you the question. Don't waste my time. We give you time to finish what you say, but don't waste our time, because there are a lot of members who would like to ask questions. So just answer yes or no. We have all the information in the report. Mr. Raymond Wong asked you if you've read the entire report. You said yes. So that is what is about of the form. Please allow me to clarify. My impression was that the CRD had a different understanding about the separation of cost. It's not the case that CRD did not about the form. From internal communications, I read that before the introduction of the form, there was a consultation of more than 1 department, but the information during the circulation was not circulated to me. The introduction used a special email, but the email was not circulated to me. Tomorrow we have the CRD with us. Perhaps Mr. Chan, you can ask the same question, because it's very clear on the document. You can ask the question tomorrow. Well, I also want to ask about Form 569. I'd like to ask the witness to read the verbatim record on 24th of May, page 30. Which one? The verbatim record on the 24th, page 36, line 27. At that time, in reply to whether beverages can be billed separately, Mr. Tong said that he was not aware that they were not allowed to engage in separate procurement of drinks. It's page 36, line 27. Page 36, line 27. Can you see it? Yes, yes. Can the witness read it? Can your witness see it? Mr. Tong, can you see it? Yes. The reply of Mr. Tong was that the ICAC was not aware at that time that it was not allowed, that is, in relation to separate billing or procurement of drinks. Let's read column 5 of Form 569. It says clearly that beverages are to be included. In paragraph 3.7 of the IRC report, it says the ADM reminded the CRD about the inclusion of beverages. Mr. Tong, in pages 37 and 8 of the verbatim record, that he knew that separation of bills of beverages were not allowed. So do you know? Is it the case that you and CRD did not know about the separation, or you knew of it but you misunderstood it? Is it your misunderstanding or the CRD's misunderstanding? Mr. Chen, please point it out in the relevant part. Refer the witness to the relevant part. Form 569. Please refer us to the relevant part of the document. 569, column 5. It says that beverages are to be included in the expenditure. Since it says that it has to be included, why did you say in your evidence that, in your view, separate a procurement of beverages was not allowed? So it's 569, the report, paragraphs 3.8 to 9, and the verbatim record. Please answer. Please be very careful, because there are discrepancies in your evidence. Thank you for your reminder. So I would like to consult my team before I answer. May I? Yes, you may, because this is a special circumstance. Mr. Tong, on the 24th of May, I said in my evidence that I did not know exclusion of a beverage was not allowed. In relation to Form 569, well, my explanation is that prior to the introduction of the form, during the consultation and the explanation during the introduction, I did not participate and I was not informed. As far as I know, there was a similar form, one similar to Form 569. There were changes, but these changes were not obvious. Mr. Tong, you have been a civil servant for decades. In relation to the CSO, the Commission's standing orders, you should know full well as the Commissioner. In your reply on the 24th of May this year, in relation to Form 569, well, the form was introduced in mid-2008. In 2009, it was revised. And in paragraph 3.10, that is, in July 2009, you have been Commissioner for 2 years by then, so you could not explain it away by saying that you did not know about Form 569. We have been very patient in our explanation to you. May I supplement? Yes. According to Cap 204, Standing Orders 11, I read it in English.
Orders, which shall be known as Commission Standing Orders. 頭先我講嗰個 CS providing for the control, direction, administration of the Commission, the discipline, training, clarification, and promotion of officers, etc., etc., the duty of officers. 所以你頭先話你喺5月24。
So you said in your evidence on the 24th of May that was the case, and now you just told us that you were not clear. But these standing orders were practically your Bible. So I give you another opportunity to consult your team before you explain to us. Perhaps the witness should be reminded that in his reply he said he signed the form. If he had signed the report, how could he say that he did not know about the form? He just closed his eyes and signed. And Mr. Tong, I give you the opportunity to consult your lawyers. Please look into it, because there is some criminal elements involved.
Director of Audit, 或者幫我手。
Director for Audit, could you help him in your report number 60, paragraph 3.24? It says, I read it in English.
Concerned with the standing orders do not clearly specify that the cost of all food and beverages, example, the wine, dessert mentioned in paragraph 3.23 should be included in part of the lunch dinner expenditure for control purposes. 咁頭先我讀嗰個 control 嗰個 CS。
Just now I read out the standing orders. You could have included that. I believe your report. I see some discrepancies. Well, can you explain to us, Director, why there is this line? As far as we understood at that time in the course of the audit, we did not see that the CRD was using Form 569. Instead, they used memo to seek the approval of the commissioner where there were where they spent above the permitted, above the ceiling. The stance of the CRD was that the beverages procured on different occasions, if they have the approval of the commissioner, would not require that. Basically, there was no existence of a Form 569 because it was not used. Beverages were the liquor, alcoholic drinks were procured separately. So you only look at the memos. You did not look at the matters in respect of Form 569. But from the paragraph I've just read out, you have referred to the CSO. Did you refer to the CSO? That is, in relation to matters stated in paragraphs 3.7 to 3.10. It seems that you did not know about the existence of Form 569. No, we did not know about the existence, but we knew that under the CSO, beverages and tips should be included under the scope of the regulation. But the CRD explained to us that that was their understanding. Am I right to understand that the audit only look at the documents supplied and Form 569 was not included? Yes, that is right. And we did not know about the exchange between the ADM in 2008. Mr. Tong, I've given you more time than I said. I did not say I did not know about the existence of Form 569, and on the 24th, there was no documents for me to refer to. My recollection in relation to the documents was not clear, but I can confirm that if I had known that separation of beverage costs was so wrong, then I would not have done it. No, that's not the issue. The CSO was one of the duties of the commissioner, as I read out to you. That is the law. So first, you did not exercise your duty under the law. Please answer me. May I to say something more before Form 569 before I move on to CSO? What I did not know was that in 2008, when the form was introduced, what the purpose was.
I did not know about the background or the rationale for the launching of Form 569. If I may read it out for you once again. In para 3.10 of the IRC report, namely the amended CSO.
Otherwise, the expenditure per head, inclusive of food, beverages, and tips, is currently subject to 你係好清楚寫明嗰度咧，呢個 CS
clearly stipulated in the CSO that this is your all. And I'm referring to Gen 3, document Gen 3. So when you come to answer our questions, you really need to read all the papers beforehand. We've all done that ourselves. Allow me to finish my point about Form 569. Yes, I have a duty as chairman to remind you. I don't want to set a trap for you. Otherwise, it's not to your advantage. I think you should follow the document, and everybody will follow the same document. If you just give us an answer out of the blue, it's not, to your benefit, and it's also wasting our time. Could you go to page 46 of Gen 33? I'll ask my team to assist me because we're talking about lots of documents. Well, you're not very clear about the papers, and you just give an answer off the top of your head, and that won't work. Well, the question is very simple. It touches on matters of the law and matters of principle, and also your responsibilities. Have you read that? I'll now give you another opportunity to answer the question. According to the IRC report, paragraph 3.8 to 3.10, the 3.7 to 3.10 2010, yes. The CSO had been amended before. The time of the amendment was July 2009. In July this year, I have just finished my first contract and was starting my second tour of my term. I had attempted to find out the date when that form was amended. The information I have tells me that it was launched on the 10th of July. I don't have any recollection of the revision of the form. When I testified on May 24th, I was not aware and I couldn't remember this revision. Subsequently, I've checked the records. In July that year, I took almost a month's leave, starting from the 4th of July. Mr. Tong, remember in 3.7b, the ADM and your raised this issue with your CRD. You were referring to paragraph 3.7. You talk about you're taking a leave, but we're talking about the year 2008. We need to be clear because we have to draft a report which is open to the public. We will not, hide or cross out any parts of our report. So please refer to the report. Don't tell us that you are on leave. You don't remember. You didn't know what had happened. I think it's very clearly, explained under paragraph 3.7b. Mr. Garrison, I don't think he's been able to answer your question. Could you go to the next question? I also don't want to take up too much of other members' time. I would like to now ask my last question. The witness have not read the papers thoroughly, and I think that would adversely affect our investigation, and I think we need to think about that. Chairman, my last question is this. In the audit report, the Director of Audit had mentioned that the separately charging the cost for the beverages is a great area. You did use such a term. But what I'd like to say is that now, since we have Form 569, this can actually help, prevent such gray areas and confusion from taking place. According to the verbatim report of the hearing on May the 24th, Mr. Tong, when answering the question about the different treatment for the charging of entertainment expenses, she said that normally 2 or 3 venues would be off proposed, and it was only a matter of minor detail. Another officer would countersign, and then eventually he would put down his signature for endorsement. So you can see that with Form 569 in place, together with certain procurement methods which Mr. Tong had stopped using, that has caused the system for the reporting of entertainment expenses very confusing. So I'd like to ask the witness whether or not this confusion arose because you did not comply with the prevailing rules, namely Form 569, and thus causing the confusion. Mr. Tong, I agree that about the confusion, and is related to the compliance with Form 569. As the Commissioner, normally the administrative matters were not my major focus. For routine matters, they were governed by a system. Whether or not Form 569 was used or not, it was actually the officer in charge who would follow specific procedures. And when there were no problems, I would assume that the operation chairman, Form 569, represents the operations of the system, the standing orders. When you sign the memo, it's tantamount to you're not using 569. Well, according to the CSO, if there were more than one procedures which were permitted, then I would think that it was not a problem. Regarding the CSO, I agree and admit that I am absolutely not sensitive to the CSO, so that on May 24th, I didn't have the CSOs on my mind. That is the part regarding the fact that the splitting bills is not allowed, and that's why I said that when the CSO was issued, I didn't have much recollection. I think this is related to the time when the CSO was launched. Mr. Tong, when the CSO was amended, you were on leave, but the previous CSO existed. So you were talking about the amended CSO. And I think that the CSO was amended during the time of your leave. But before it was amended, the CSO already existed. Chairman, I still like to point out that according to the PAC report, para 3.10, in July 2009, the CSO Part 1, Chapter 25, Section 4 was amended to state explicitly that expenditure per person on entertainment should include food, beverages, and tips. I understand this, and although the CSO existed before, but before it was amended, its nature was different. Well, if you talk about the CSO before it was amended, Form 569 was already there. That's why I asked Mr. Gary Chen to read out the form to members. Let's not debate on this point any further. Alan, your turn. Thank you. Just now, Mr. Tong said that he was a very busy person, and normally such administrative matters would not be his major concern or focus. Well, this time he had not used Form 569, and also the costs for the liquor was separately were separately charged compared with the for the cost of meals. Was that the idea of Julia Mo? I can't say whether or not it was a certain person or it was the idea of Madam Julia Ma. I simply, dealt with the application that was put to me. Who put that application to you? Well, different people would submit different applications to me. Julian Wu was the director of the CRD. Normally, you have an officer in charge, and this officer in charge was either Madam Julian Wu or his subordinate.
So it might not have been Julie Mu herself. But then, in any case, it would have been via a more senior officer. It could have been a directorate grade officer. It depends on the application. Sometimes it would go through a number of officers. Mr. Leung, well, Chairman, I'd like Mr. Tong to understand the reason why we are asking him to come again at this hearing. That's because in the wake of the IRC report, we noticed that in several critical areas in May and June, when he gave evidence to this committee, the picture that he gave us was somewhat different from what is shown in the IRC report. That's why, before we come to any conclusion, we try to be fair, as always, to the witness. That's why we give him a second chance to explain things to us. That's why I'd like to refer Mr. Timothy Tong to the IRC report 3.9. Yes. during the interrogation by the chairman and other members, you were also aware that concerning Form 569,
修訂常規第1部25章第
Chapter 25, Section 4. I think there's a background to this part. The background is that in 2007, there was, since you needed to procure multi, and therefore the expenses exceeded the threshold, and therefore the cost for the procurement of multi was separated from the cost for the cost of meals, and then the ADM was not happy about this, and therefore they insisted that there should be this form. If you go to para 3.8, it is stated that the finding of the PRC, that is Form 569. 6 months after it was introduced, the CRD stopped using this form. At the time, Madam Julia Mu was the director of the CRD. Is that right, Mr. Tong? Yes. If the CRD decided not to use Form 569, can I then presume that this definitely was the decision of Madam Julia Mu? Mr. Tong, would not this was the decision of Julia Mu, the director? I can't say that I know, but Julia Mu was the director of this department, and the head of the department would know about this. Alan, Mr. Tong, as the commissioner, would you accept and allow the head of the CRD to make the decision of not using the Form 569, and you would accept that? Well, I've already said earlier that I believe Julia Mu, as the head of a department, should know that form was not used. Could you answer Mr. Leung's question? You've not answered Mr. Leung's question. I believe that as the director, she knew. Alan, Mr. Tong, Mr. Gary Chen already repeatedly read out to you the evidence you gave this committee on May the 24th. During that, he read out from the verbatim report of that hearing. Why are we asking you this detailed question? Because this is one of the areas in which your evidence, the evidence you gave on that day, are not consistent with the findings by the IRC. The impression you gave us at the time was that before you had access to the Director of Audit's report, you didn't know that the cost for the procurement of liquor could not be separated from the cost for the procurement of food. As the verbatim report clearly indicates, you even said during that hearing that even the Director of Audits found this to be a gray area, and since he said that it was a gray area, it wouldn't be a surprise that I didn't know myself. This was what the PAC heard from you on the hearing on May the 24th, and this impression is actually not consistent with the picture painted in this report by the IRC. That's why I like to point out to you, or you may not choose not to agree. On the 24th of May, when you testified to this committee, you deliberately hid the facts. You knew actually well in advance. And after the revision of Form 569 in mid-2008, and also in July 2009, when the ICAC amended Part 1, Chapter 25, Section 4 of the CSO, you knew very clearly that you could not actually, charge the cost for the procurement multi separately. You hit the facts that you knew about it at the time, and you simply said that before the Director of Audit's report was available, you didn't know. If the Director said it was a grey area, you have very good reason to justify yourself. Chairman, I totally don't agree. And I think the allegation that was deliberately hiding the fact is a very serious allegation. He did not say that. He just asked whether you agree or not. If you don't agree, how do you explain what Mr. Leung had just pointed out? Mr. Leung, I think you may also go to para 3.7 of the PRC report. Other than not complying with the, other than the CRD, another department, the admin department was in compliance. Mr. Leung, you quoted from paragraph 3.8 to 3.10. Could you also go to 3.7? Because it's in our record. Chairman, through myself, the Chairman would like to invite Mr. Tong to go to para 3.7 of the IRC report. I believe, Mr. Tong, you have already read this. Here, in this paragraph, it says that normally, well, in B, it is said that the Operation Department and the ADM would advise that the cost of alcoholic drinks should be included in the expenditure for the entertainment, and the CRD did not follow that. So this Form 569 has a purpose, that is to standardize the practice adopted by all departments in the ICAC. You said that as the Commissioner, you didn't know that about the background of Form 569. You even said that in July 2009, when the ICAC amended its standing orders, that is Part 1, Chapter 25, Section 4, and you didn't know about that. I totally do not accept it. I think you are just making excuses. Do you agree?
Thank you, Alan. Now that you've set it out very clearly, that would also give him a chance to respond. Mr. Tong, Chairman, I do not agree, because I think this is a very serious allegation. That's why, once again, I'd like to request that before I speak further, I'd like to consult my legal counsel. All right, please take the opportunity to consult your two legal friends before you reply.
係啊，睇翻嗰個面都跟啊，你睇翻嗰個表出嚟，嗰個其實 ICC 要嘅，喺個邊入邊真係。湯生啊
Mr. Tong, I'd also like to refer you to Annex 1, because ADM is directly under you, so when you consult your counsel, please also refer to that. So ADM is directly under you, so the administration department is directly under you, so you know where you stand. So I'm just pointing that fact out to you. So you can refer to Annex 1 in the IRC report, Annex 1.
Alan， 我俾緊時間你。
Alan, I'll give you back some time.
湯生啊，我今次係
Mr. Tong, I've been very accommodating on this occasion in the sense that I've repeatedly allowed you to consult your legal counsel because there is a criminal angle to this. I hope that you would understand your position. However accommodating we are, we have to follow the facts and the documents. And just now, I once again reminded you that in your answer to Mr. Raymond Wong's question, you agree that there were two problems with this report. That's about your trips. But then with regard to 3.10, so when you responded to Mr. Wong's questions earlier, you already responded to that. I understand that you are subject to a lot of stress this morning while you appear before us. Well, I have been reminding you from time to time, but then I cannot remind you every time when this is involved. I've been giving you time to look into it or consider it, and if you're not aware of that, if you do not know, just tell us. Please do not walk us up the garden path, because we cannot tolerate that any further. All right? Thank you. Chairman, I do not agree with the allegation that I had deliberately hid the facts, that I knew that it was not right, but then I deliberately hid that from the PAC. On the 24th of May, my mentality was as stated in the transcript. All along, my impression was that there were two systems to deal with entertainment applications. Well, sometimes you would use one form, at other times you would be using other ways, and if both are working, then approval would be given. So there is no question of any motivation to cheat. And with regard to 569, as I pointed out, with regard to the rationale behind this, and also in September 2007, with regard to the entertainment consideration, there might have been some internal discussions, but then I was not involved in that whatsoever. And I was also not aware of that discussion as regards the introduction of the form and the purpose of that form. That was not brought to my attention. So that's my impression. So my impression was that the system was working, and of course it can be improved. And then on the 24th of May, of course, I did not have any recollection of this CSO. And then subsequently, when I read the IRC report, I also had to find out why there had been this change to the CSO, resulting in this, and as a result of that search, I was aware that I was actually on leave during that period of time. Thank you. Mr. Leung. Chairman, I'd like to point out to the witness that according to the IRC report, well, when Form 569 was introduced, in fact, all departments within the ICAC, including you yourself, after you assumed office, you also set up this office you call that Office of Strategic Research. So including this OSR, they all follow strictly Form 569. Only Julie Mu, she's the head of the CRD, the Community Relations Department, and it's strange that that department was the only one in the ICAC after the introduction of Form 569, which did not follow and use Form 569, and as Commissioner of the ICAC then, were you aware of that? Well, Ellen, you might wish to ask him again. That is, before the CRD, who was responsible for the procurement? Was it the ADM? So when did the CRD take up this job? All right, Mr. Tong, you heard the question raised by the chairman, so can you just answer the chairman's question direct? All right, 2 points here. All right, before you assumed office, was it the ADM which was responsible for the procurement of such items? And when did the CRD take over this duty with regard to the procurement of liquor? And Mr. Leung then asked you a question, so please answer both. Chairman, your question in relation to which department was responsible for the procurement of liquor? I cannot be sure about this. I am not able to give you a definitive answer because the CRD was not supposed to entertain people. That's under para 3.7. All right. Previously, if you refer to para 3.7, is set out very clearly. So how come all of a sudden the CRD would go out to procure liquor? It should have been done by the ADM, the administration branch. The CRD is responsible for community relations, and it was responsible for organizing entertainment activities. So if you do not answer the question, so I'll be putting that to the CRD tomorrow. So can you answer the question raised by Mr. Leung? I was trying to intercept because I'd like to clarify this with you. Well, in para 3.7, it says that the Office of the Strategic Research also separated that from the general expenses. So, with your approval, you can separate the bills so that the amount would appear lower, so that there would not be any exceedance of the threshold. So how come we have this coincidence? Because this office is more closely related to you because you set it up in the first place, and also according to Julie Mu, well, for most of your duty visits itinerary, upon her assumption of office, it was arranged by the CRD. So has it got to do with this? All right, that's why the OSR also had this special arrangement. They had the privilege, that is, you have already given them the green light, and therefore they did not have to fill in 569. But then for other departments, they would have to follow 569 strictly. Mr. Tong, no, we would not be making different arrangements for different departments. And then in para 3.9 for the CRD, whether or not they use the form, they would not include the cost of alcoholic drinks in the expenditure for entertainments. It shows that the CRD all along had this understanding, and that was the cost of beverages would not have to be included in the expenditure for entertainments. Can you answer the question asked by Mr. Alan Leung? Did it have a special power? I've already answered the question. No special arrangements. But then can you explain why only the CRD was not required to use this Form 569, and then for the other administrative departments and other departments, the ops, they all had to use that form? Why? Well, I'm not able to speak on behalf of the CRD as to its interpretation of this, but then according to 3.12, well, the CRD gave an explanation. That is 3.10. They said that, well, their understanding is that the expenditure per person for entertainment should include food, well, that would not be calculated. That's why it did not include that. But then that was because you were the then incumbent commissioner. Is that right? Well, yes, I was the one giving approval for such expenditure items, and as they were given the green light by you, that's why they did not have to follow 569. That's the question that I've been following up with you. So can you give us a definitive answer? Are you going to answer that or not? Well, Mr. Tong, before you answer that question, you read out para 3.9. Once again, I'd like to remind you that in para 3.9, CRD, well, upon the introduction of 569, within the first 6 months, it did use it, but then after it was, it only stopped using that form after 6 months. So in your already answer, all right, if it had never known about it, and that's why it did not use it, well, that might have been one of the reasons, but then that's not the case. So I'm reminding you that you refer to 3.9, and then in 3.9, can you just read that? Can you just read 3.9? Can I just read that out to you? In para 3.9, is about the use of 569.
Half a year, CRD stopped to use the form.
So that was in relation to the question asked by Mr. Leung. You the suggestion that it was not aware of this form. So indeed, it had used this form before. Well, let me clarify. Yes, I was reading the Chinese version, but then you were reading out the English version. Regardless of whether the form was used or not, CRD did not include the cost of alcoholic drinks, which were beverage procured separately in the expenditure for entertainments. So that's the way I read the IRC report. So the approach adopted by the CRD was consistent. Concerning Mr. Leung's remarks that it was given the green light, or it was given this license to do whatever it wanted. Well, assuming that there was this need, whether it was done in a form of this standard form or via memo, if the applicant thought that there was a need for the entertainment expenditure ceiling to be exceeded, then they could always approach the commissioner for approval. Well, since you've been giving approval every time, that's why Julie Mu, the director for CRD, decided not to use Form 569. And therefore the culprit was you. Was that what you meant? I do not agree. Once again, I'd like to say that this is a very serious allegation, and the honorable member said that I repeatedly approve that. If it's a decision to use or not to use Form 569, still the commissioner would have had the power to approve that expenditure, and whether it's within the budget or in excess of the ceiling, the power still rests with the commissioner to approve or not approve. Well, in exercising that power to approve, do you understand that there was this Form 569? Well, I was aware of the fact that we had Form 569. I never said that I was not aware of the existence of Form 569. But then, well, on the 24th of May, without the reference to this document. All right, you were aware of Form 569, and then you also approved it via memo without Form 569. And as Mr. Chen earlier asked you about beverage and tips, that should have been included. So did you exercise or discharge your duty under the ICAC ordinance? It was provided very clearly there. As Commissioner, you had the duty. Did you exercise or discharge your duty? You had the fiduciary duty to the public of Hong Kong. That is, you will have to act as the gatekeeper. All right, procuring alcohol is just a minor matter, but then did you discharge your duty? Because that was your duty. So did you discharge your duty? So do you understand it? Well, and when you exercise your discretion and privilege to approve it, so how come this could have happened? All right. I understand that as Commissioner, one should discharge his duty under the CSO. And I cannot deny that. That is, in the course of discharging my duties, there was an obvious inadequacy. And according to the series of questions put to me by Mr. Alan Leung, I have to point out that it has nothing to do with a deliberate omission. All right, if it's not deliberate, then have you not asked yourself, well, how come only these two departments had the privilege and not the other departments? And as ICAC Commissioner, did you ask yourself, how come that would have happened? Because ICAC should have dealt with everything very fairly and openly. How come, from this perspective, how would you respond to our question? How can you convince us that what you said was the facts?
反覆
As I've said repeatedly, that there were two systems, the use of a Form 569 or not. And for quite some time, these two systems run in tandem. And in the actual operation, when it comes to details, I rely on the system. Unless there is something special, I would not pay special attention to it. And so I don't know why I did not know about the purpose of 569 and also the revision. I've already said that I did not participate in the consultation of 569. I was not aware of the background. And when CSO was revised, I was on leave. As a result, on the 24th of May, my understanding was that there was nothing wrong in using both systems. Let me say again that yes, you were on leave when the CSO was revision. We don't know that you were on leave in July 2009, but when the form was introduced, you said you knew. You knew of the existence of 569 prior to July 2009, so you cannot say that you did not know. This is not a court, but this involves effective governance. So this is related to value for money audit. This may not be a court, but we're here to find facts of this matter based on documents from various sources. You said you did not know about the CSO. Yes, I might accept that you did not know about this when you were on leave, but after you have come back to the office, you would know. So prior to the revision, there was still the existence of this form in the CSO. Please refer to 3.10. Well, it's mentioned in 569 too. Alan, would you ask your question again? In relation to the background of Form 569, we all know full well. The focus is focus was to separate the beverage and tips from the expenditure of the meal, but you use public money to procure multi. You wanted not to be discovered. You wanted to circumvent so that you will not exceed the permitted expenditure. Well, I've spent too much time on this point, and I'll move on. The disuse of Form 569 and in its place an application to the Commissioner on every occasion for separation of bills. Is this your idea or the idea of the head of CRD, Julie Mu? Mr. Tong? I deal with the applications when I receive them. I discussed with my colleagues. I did not pay special attention to when Form 569 was disused. In relation to daily operations, say for example administration, I did not pay special attention to it. So it's not the case that I asked my colleagues to use Form 569 or not to use it. So the decision to disuse Form 569 was the idea of Julie Mu, head of CRD. It's not your direction from top down. Yes or no? Mr. Tong? Oh, well, I think it's by logic. It's not my idea. It was not my idea. But does it mean that it necessarily had to be someone's idea? I cannot be sure. Where's the logic? Where's the logic? So it's the fault of society? No. But it's not your idea, it's not anyone's idea, but there was an approval. It has to be logical. Well, but it's not my idea. Does it mean that it's someone else's idea? Mr. Leung asked you whose idea it was, but I did not know. Well, it was Miss Mu's. Well, who gave you the form, then it would be her, but you said it's not her. There are other ideas. There are other views. Well, this is how I see it. It's not the case that it's either A or B. It's not either or. And if it's not my idea, is it Julie Mu's idea? Well, I agree that she was the head of CRD, so she should know. But as to whether it was her idea, it was her initiative, well, I don't know. That's how logic stands. Alan, it doesn't really matter that you don't understand his logic. Please continue. Oh, well, never mind. We can draw our own conclusion. I think it's meaningless for me to dwell on this point. I have other questions on duty visit. I don't think we can finish in this session. We may need Mr. Tong to come back, because Mr. Leung has yet to ask questions, and some members have only asked questions related to one part. Mr. Tong, I think I have to trouble you to come back again. I don't know how many more times. We have spent a lot of time to read what you should have read and to tell you where the documents are. We did our best to try to finish today, but that's impossible. Mr. Leung, you want to ask questions today or wait till next time? I think he's tired. But if he's tired, then next time then. Okay, that would be fair. Mr. Tong, we will ask you to come back to ask you more questions. And please, read through all the papers, documents, and report. We will confine ourselves to the documents. ICAC ordinance, CSOs. We have all the documents that you have. If you don't have them, ask us. Thank you. Thank you. Meeting adjourned, and we will fix it another time for parties to come back. Thank you, Director, for audit. Tomorrow at 9 is Simon Pei, Commissioner for ICAC, and Ms. Mu, the head of CRD.